Hi, we are Group 2 and our topic is Sources of International Law, and this video is to share the 3 cases under our topic.
The case I would like to discuss is Nicaragua versus the United States. In this case, the Nicaragua brought a suit against the United States on the ground that the United States was responsible in the illegal military and paramilitary activities in and against the Nicaragua. The case is about the Nicaragua had changed the new government, and actually at the first the United States support the new government. However, they changed their attitude when they found that the new government providing the logistical support and weapon to the guerrilla in El Salvador. And then the United States stopped the aids and they plan and undertake activity direct against the Nicaragua. And the United States support the two groups, FDN and the ARDE, which call as Contras, to fight against the Nicaragua government with the aim to overthrow the Nicaraguan government. The United States also carried out the direct attack against the Nicaragua. The principle is the customary law is the sources of international law, but certain kind of custom is not accepted as the sources of international law. While in this case, the customary international law are rejected by the ICJ. So we will discuss why that the ICJ reject using the customary international law in this case. Before of that, the court held that the issue raised by the Nicaragua actually related to the use of force and self-defense, which were regulated both by the customary law and the treaty law, in particular the Charter of the United Nations. But due to the United States has entered the Venerable Reservation, so the court cannot rely on the Charter of the United Nations. In this case, the ICJ used a lot in the customary law. In customary international law, actually allowed the exception, prohibition, use of force if the criteria meet when they're using for the self-defense. At the first, the court held that the United States actually violated its customary international law obligation not to use force against another state when its activity with the contrast result in the threat or use of the force. And the United States could only justify its action on the basis of collective self-defense. And the court found that the three countries, El Salvador, Costa Rica, and Honduras, none of the countries declared themselves as the victim of under attack by the Nicaragua. Besides, the court also found that they did not request from the United States to exercise its rights to self-defense. And the United States also did not report that it was acting in self-defense to the Security Council. Thus, based on the above, the ICJ conclude that the United States cannot justify its use of force as collective self-defenses. So, which means that actually the United States didn't fulfill the requirement in the opio juris in using the customary international law as self-defense in this case. Besides, I also found that the principle of non-intervention is customary law. And in this case, we can see clearly that the United States actually intervention directly in the Nicaragua internally. The United States helped the groups to fight against the Nicaragua government, and they also attacked against the Nicaragua. So based on the fact that we've discussed, the United States using the customary international law as self-defense are denied by the ICJ.
Later.
The Treaty of Rome is a treaty that was established in 1957 in the European Union. The Treaty of Rome is also known as the EEC Treaty because it established the organization of the EEC, also known as the European Economic Community. The Treaty of Rome was signed by 6 countries, which were France, Italy, Belgium, Luxembourg, the Netherlands, and West Germany, and was signed in Capitol Hill in Rome on 25th March 1957. This treaty was an important step in economic advances in Europe because the Treaty of Rome proposed the progressive reduction of custom duties and the establishment of customs in Europe. This treaty is done to ensure that a single market is created for goods and services as well as labor and capital across all the participating states, and economic actions can be taken to ensure the economic benefits of all these states. It also proposed the creation of policies such as the Common Agricultural Policy, the Transport Policy, and the European Social Fund Policy, related to customs and trade in Europe. This treaty has since been amended in 1957. Recent treaties such as the Maastricht Treaty and the Treaty of Lisbon are treaties that have since amended the Treaty of Rome to make sure that it is more up to date with the current world. It can be seen that the Treaty of Rome is a source of international law because the participating countries agreed to mutual benefit and mutual agreement in signing the treaty to ensure that there is peace and harmony across the states. There can be consequences if the treaty is breached. Therefore, it can be said that this agreement can also be a sign of international law because it is an agreement between the participating countries. Therefore, it can be said that this treaty is a source of international law. Thank you.
A few moments later.
Assalamualaikum to my beloved lecturer Dr. Ratna. My name is Aisyah Nabila binti Sheikh Abu Bakar and I'm going to present for the last case of source of international law. I have chose the case of whaling in the Antarctic, Australia versus Japan, New Zealand intervening, which this case related to treaty. On 31st May 2010, Australia initiated legal proceedings against Japan in connection with Japan's continued pursuit a large scale of whaling program. Under the second phase of Japan's whaling program, under the Special Permit of Antarctica (GRAPA2), which violated its responsibilities. Japan, under the International Convention for the Regulation of Whaling (ICRW), as well as other international obligations for the conservation of marine mammals and the marine environment. On 20 November 2012, New Zealand filed in the registry a declaration of intervention in the case. Relying on Article 63, Paragraph 2 of the statute, it argues that as a party to the ICRW, it has a direct interest in the development that may be placed on the convention by the court in its decision in progress. In the order of 13 February 2013, having stated that New Zealand met the condition set out in the statute and rules of the court found out that the declaration of the intervention was admissible. Japan argues that GRAPA2 is included in the exception compiled in Article 16 of the ICRW, which empowers the contracting government to issue special permits to its citizens to kill whales for the purpose of scientific research. Then to the question to the interpretation and application of Article 16 of the 1946 Convention Paragraph 1, which state that parties may grant to any citizen a special permit authorizing that citizen to kill, take and treat whales for the purpose of scientific investigation. After the discussion with experts, the court noted that although the whales program involves scientific research, the killing, retrieval and treatment of whales in accordance with such a program is not included in Article 8, unless these activities are for scientific study purpose. The court concluded that the special permits granted by Japan for the killing, retrieval and capture of whales in connection with GRAPA2 were not for the purpose of scientific research. As the conclusion, the court then turned to the implication of that conclusion based on Australia's opinion that Japan had violated certain provision of the schedule attached to the convention. Having found that Japan had indeed violated several provisions of the ban commercial whaling and factory vessels and the ban on commercial whaling at the Southern Ocean Sanctuary, the court ordered Japan to revoke any extant authorization, permit or license not to grant further permits under Article 8, Paragraph 1 of the convention to make the program a success. Last but not least, I found that in this case, the treaty in international law has functioned in binding the agreement between the state parties. So this is all about our discussion on these three cases that we choose. Thank you for watching.